Your Honor, that would not be my preference. I would like to have.
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause. All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only to.
Be heard?
Because you're acting like the attorney.
I'm acting like the court, and you owe me $50, ma'am, for contempt. And if you have another outburst, it's going to go up, and it will be enforced. $50 direct contempt by Nicole Johnson for her interruption of the proceedings. Miss Carter.
Yeah, because you want to retaliate against him, don't you?
Miss Carter now owes $200 in fines, and I'm disconnecting this call so I don't have to send the Greenwood County Sheriff to whatever state she's in to get her picked up and locked up for contempt. This hearing is adjourned.
Ma'am, every time.
It's case number 2025 TR 1215. Quentyn Height appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. For Height, court has an information before it which alleges in count 1 a charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count 2, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Height?
Good afternoon. I do not intend to plead.
Why is that, Mr. Height?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Height. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
Let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Height. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have.
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one.
I do comprehend this. Thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentyn Height under it, pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Height, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for that.
I do believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
Court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Height. It'll
Okay.
be your first appearance with following today's date. I'm going to set
Would
the
you
hearing
repeat that again?
time at 3:00 p.m. You may
My
appear
apologies.
by Zoom.
Is there an
3:00
in-person?
Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And
But-
which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll
Okay.
be participating by Zoom, but you can participate from the Judicial Center. So make
Okay.
sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3:00, he's going to represent himself. And the court has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what
Okay,
judge?
just a
and
minute,
what
I'm going to ask the prosecutor. Mr. Regier, is there anything else that we need to address regarding Quentyn Height at this time?
Not on this particular matter, Your Honor, although per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's order today, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good. Your
So
Honor.
let's go ahead and cite for Mr. Height, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9:00 a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Regier?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3:00, Mr. Height. I
Thank you
think
for
that concludes our business on
I have
the
one
case at this time.
One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said, you mean in this case that was before the court today?
Correct.
This judge is hearing the case. Okay.
Thank you for clarifying.
And if there's nothing further, the Quentyn Height matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.
Your Honor, can I please go home? I'll leave.
All right, well,
Can I go home?
I left it up to them and I left it up to you and then they were to behave accordingly.
And you get a
No,
speeding
we're not
ticket.
gonna do that, sir. I just need.
All I want to know is the fine. Like normally when you get a ticket or a citation, somebody give you.
I've told you that. I've told you that.
When you held me in contempt, they went out and searched my car, which was a violation of my Fourth Amendment right. They never issued me a search warrant. They never told me my vehicle was suspected in a crime investigation or any kind of criminal intent or doing anything. So my car was searched.
Well, I think you, as I understand it, you were put on lockdown because you wouldn't go through booking and processing. They couldn't get you entered into their system.
No,
You
well,
refused to get your fingerprints and you refused to get your photograph, and rather than manhandle you and wrestle you and get you to take your pictures and prints, they had to just put you somewhere safe until you would cooperate. But
that
that's
wasn't
what
the
I've
case.
heard. I don't know that for a fact.
Well, if you look at the video, that is inaccurate. When I came in, I was told I was
Well,
gonna be.
okay, sir, we'll talk about that just a little bit. Okay, well, Missy, there's no one else hanging around like.
No, Mr. Johnson has called again this morning
Oh,
and
yes,
he's
yes.
supposed to be faxing something. My fax machine just went off, so let me see what it is.
Is this the individual who's
This
a sovereign citizen type?
Sovereign
thing?
citizen military. Yes, and he is really military.
Sovereign citizen in the United States military?
Yes, I have something he sent us. Mr. Johnson he's filed several pro se motions. I'm not quite sure what they're saying or what his goal is. I had told him to be here in person because of his prior history and contemptuous behavior.
I asked that we set this over to October 25th.
All right, I'm looking for a Johnson. Do I have a Johnson?
Yes, you do. I am
Danny?
here. Can you hear me?
Yes, but you're not the Johnson I was looking for, but I will take your case up. I have a couple. I have a Danny Johnson, and well, don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
What does that
And
mean?
that means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney, in fact.
You're not an attorney at law?
No.
Okay. So when
So-
you say
so
you're an
Mr.
attorney, in
Johnson-
fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No, I'm
right?
not a citizen. I'm not a citizen. But let me state for the record, Mr. Johnson is under doctor's care. He's in recovery. We sent the documentation over to the courts to show that, to show proof of that. We also reserve our rights to any and all reproduction of or distributing of videos on social media platform. And we request the matter to be rescheduled at a later time when he can get through his recovery period.
All right, Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first appearance. He entered a not guilty plea. Actually, he objected, I think, to just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings. I believe he
I
was.
object, Your Honor. I think he was
Stop,
just.
stop.
He was-
You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss Carter. I'm not Miss Carter.
Then why does your screen say Sasha Carter?
That's what it says, but I'm not Miss Carter. And it says
Who are
Sasha.
you? Who are you? Before I disconnect you from these proceedings, because you don't have standing to be here. What's your name?
Well, again, Mr. Johnson is under Dr.
Do you want to
Mr.
tell me
Johnson is
your
here.
name?
He's here. I've already gave you my name, ma'am. I'm his
Well, then
wife.
say it
I'm
again,
Miss
because I
Johnson.
must have missed it. What's your
Miss
name?
Johnson. Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
Nicole.
Nicole Johnson. And you said you're his wife. Is that
That's
correct?
correct. That's
You're
correct.
his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27th. And on September 27th, there was an issue that he either was or was not receiving medical service. And he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago. And you say he's still under doctor's care and can't be here today? Or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days
actual
ago,
surgery.
he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing at, on bed rest. And we sent in the documentation to the courts and the doctor. The doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
And we've made it clear to him that he can appear by Zoom. So I'm going to issue a bench warrant, bond forfeiture.
Hold on one second, ma'am, because he is here. He can hear you, but it's
put him on here.
Oh, he's on here, but he's in a recovery bed, ma'am, and it's a violation of his rights, his HIPAA rights, to be shown and be broadcasted all across social media as far as
bench warrant, bond forfeiture, no bond hold.
Ms. Western.
Oh, now do you want to be on here, sir?
Well, I'm first of all,
Are you voluntarily appearing, Mr. Johnson?
No, under duress.
I'm not.
Okay, I'm not duressing you at all. You don't have to be here.
Can I speak, please? I just want to let you know I'm on a series of medication that alter my. I'm on a medication that I'm supposed to be on bed rest from my procedures for the next 8 weeks and for the following 8 weeks, and then I'm supposed to start my recovery. But I have reached out to the courts. I have had the hospital reach out to the courts in reference to my procedure and my process. I have requested a continuation. I have also sent in letters to request evidence from the case to continue the case prior to these procedures that I have not got a response back. So
certified mail.
I sent it out registered mail that the courts received, I think on the 23rd, in requesting evidence of the case to continue prior to my surgery, but having the surgeon
it's an unforeseen circumstance.
Ma'am, I want you out of the case now. You're not his lawyer. He's talking, he's representing
Ma'am,
himself.
the creator
Out.
made me his wife, and
I will find you in contempt of court.
Ma'am,
Stop talking, Miss
I just-
Johnson.
Okay.
Now, both of you stop for just a moment. Miss Gillette, you haven't had a chance to say anything on this. Do you wish to be heard?
because you're acting like the attorney.
I'm acting like the court and you owe me $50, ma'am, for contempt. And if you have another outburst, it's going to go up and it will be enforced. $50 direct contempt by Nicole Johnson for her interruption of the proceedings. Ms. Gillette, do you wish to be heard?
Good luck with that.
Ms. Gillette?
Sorry, I was making notes, Your Honor. In this matter, there have been lots of issues with Mr. Johnson. There is a letter here. I don't know if it came directly to my office or through the court. It's through the court because it was filed in the court file of
All right, so when
his-
you say through the court, you mean it went to the clerk?
It went to the clerk
Okay.
and was file stamped. There
And it
is
may or
a-
may not have made its way to my office, but if it has, I haven't seen it for the record. Go ahead, please.
there is a note from September 25th, 24. His other hearing would have been the 27th. Asking he be excused. We've had lots of issues with Mr. Johnson in the past. I am taking into consideration that he has provided a doctor's note and information about
Okay.
that
But
visit.
that was the last hearing. What do you have, if anything, for today from the doctor?
That was received. It was file stamped 9/27. I don't know if he's recovering or not. I can't tell you anything about that. So if he is on medication, Judge, I don't want to have anything substantive unless he's not taking pain meds. So I would move it over to November for him to be here, present, and he needs to understand that attorneys can speak for individuals, but not family members unless there's some sort of.
He won't be released in November, ma'am.
Ma'am. Miss-
So-
$100 fine or for contempt against Ms. Johnson?
Miss-
Okay,
yeah,
now,
the
Mr.
court.
Carter, you may speak. Yes, sir. Now, if you're
Ma'am, do you even know who you're talking to, ma'am? Because you're calling all these names. Which name, who are you speaking to?
you told me your name is Nicole Johnson. I'm speaking.
Correct. So
to
you calling Carter, and I expressed to you that nobody's here is Carter.
Well, don't have to put Carter on your screen if you're not Carter.
Ma'am, we made the point to be here in court today, ma'am.
You
And that's under
stop
the
talking.
unforeseen circumstance. He's still
All
here.
right,
in court.
I'm
He's not
going to
doing
end this
unlawful
talk.
acts
This
against
court is
him.
over. Bench warrant, if you don't stop and get out of it. If you don't want this bench warrant, you be out of this conversation and let
Ma'am.
me communicate with the defendant.
Ma'am,
Obviously,
there's no
Mr. Carter
defendant.
doesn't have any
He hasn't been
control over
convicted
you.
of anything.
Okay, Mr. Carter, I'm gonna have to end this court because the woman won't shut up. And I'm gonna have to leave a bench warrant. If you can get her to shut up and stay out of the conversation, you and I, sir, can have a hearing. Now. Okay. How much time do you need this continued, Mr. Carter?
The doctor can send over the information.
I would request.
Mr. Johnson, I'm sorry, Missy, can you get that Carter out of here?
Hey, I'm trying to explain to you. The doctor told me it's going to be 3 to 6 months for my recovery.
3 to 6 months.
So I had a. So it's a middle back procedure. Like I said, I haven't even started physical therapy yet.
Do
So,
you have an attorney, or would you be willing to take a court-appointed attorney?
As far as the attorney, all I would coming to do is, because I'm on medication, I don't want the court hold anything against me that I may say due to the type of medication I'm on. And
I
two is the
understand.
fact that I am requesting a continuation. I know y'all saying I've been whatever, but at the end of the day, I'm requesting a continuation at least to December, late December or January.
All right, we're gonna set this over for trial. It'll be for bench trial. And what the doctor told you you'd be in recovery for how long?
I be 3 to 6 months for
Okay, so this
recovery.
is October, November, December, January. I will continue this. Missy, what do we have mid to late January?
January.
Very ethical.
Is that month that is really challenging?
Yeah, but we do have January 31st at 11 available.
All right, January 31st will be your bench trial. Now, did I understand that someone did receive something from his doctor today or recently? Ms. Gillette, you were talking about something from a month ago.
What time?
Yes, it was filed September 27th. It said he had surgery.
Yeah,
And it was an
that we
excuse for the
continued that
27th.
hearing based on that letter. We continued it to today. But has anybody seen anything more recently?
No,
I think the wife was reading something that said he couldn't travel, but I don't think it said anything about appearing by Zoom. I think it just said he couldn't travel or appear at that.
What's happening here is a classic competence trap. Rejecting counsel feels like control, but legally, it removes the only buffer between confusion and consequence. In court, confidence without expertise doesn't protect you. It accelerates mistakes that the system will not correct for you.
In that fashion. But that's what we need to make sure come January, that the doctor understands this can all be done by Zoom. And again, Mr. Johnson, would you consider appointment of an attorney to represent you?
Not at this moment, Your Honor. Like I said, I'm on medication.
Well, an attorney could sure help you navigate through this court system. I understand you wanted to represent yourself, but the attorney could sure help you.
I don't need an attorney at this moment.
All right, we'll document that for the record, Ms. Gillette, in the journal entry that he still does not want an attorney. That we are continuing this again at the defendant's request for medical reasons to January 31st, 11 a.m. Now that's going to be for bench trial, so keep that in mind. The state will have their witnesses ready, and if you have any witnesses, you'll need to have them ready. Hopefully, you won't be under medications January 31st or in any situation that's going to affect that. But I won't issue the bench warrant. Nicole Johnson does owe me $100, or she owes the court $100. I'm going to give her 10 days to pay that. If she doesn't pay it, then she's going to face more contempt. That payment needs to be paid, Ms. Johnson, to the clerk of the district court. And that is in Eureka, Kansas at 311 North Main. And make sure you put on there contempt for case number GW 2024 TR 22. And put on there that it's for payment for direct contempt of Nicole Johnson for continued, well, you won't have to put on there other than for contempt. But I do want the rest of it put in the journal entry, Ms. Gillette.
Well, if somebody tries to defend themselves, it's contempt. Or exercise their rights, it's contempt.
Ma'am, you don't have any rights in this hearing today.
I do. I'm not a citizen, ma'am.
I don't care what you consider yourself. You do not have any right to come into any court of law and start interrupting and delaying the procedures and absolutely deliberately and intentionally disobeying what the court instructs you.
Ma'am, I called the county attorney yesterday. I called the clerk yesterday.
I am going to tell you to stop talking one more time before I
know, because you don't want me to express my rights.
This is not your hearing. This is not about you. I really
Well,
hate
you're
to
making
have
it
to
about
send
me,
the
ma'am.
sheriff to
You're
whatever
making it about
state
me.
you're
You have
in.
not,
like
you
we're
have not
written
given
to
no
the-
lawful consideration to this matter,
Mr.
ma'am.
Johnson,
Under the doctor's care. He has provided all the documentation to show that he's under the doctor's care, ma'am, and you have not given no consideration to that.
you are so fortunate
Jeanette.
that you're not here in person, or you'd be locked up right now.
Yeah, I am
And
fortunate.
Mr.
Thank you.
Johnson
God
will
gives
be
me
locked up
fortune.
if
God
he
gives
is
me
not
that. My
here
Creator
in
gives me that.
person. Mr. Johnson is ordered to appear in person for bench trial, January 31st, 11 a.m. Ms.
Yeah,
Carter,
because you want to retaliate against
Okay.
him, don't you?
Ms. Carter now owes $200 in fines, and I'm disconnecting this call so I don't have to send the Greenwood County Sheriff to whatever
Yeah.
state she's in to get her picked up and locked up for contempt. This
Ha,
court
ha,
hearing is
ha.
adjourned.
Ma'am, every time
Missing-
somebody expresses their lawful rights to defend themselves, you hold them in contempt. Why is that? You are a judge. You are compelled to provide protection for we the people. You acting as an attorney, giving advice to people, talking, bringing people down, and he's in a situation to where he's under doctor's orders. It's a shame that you still wanted him to present himself under the doctor's orders of bed rest and medication before the court.
Put the camera on yourself
so
when
you
you
can
talk to me,
extort
Ms.
them,
Carter
and you
or
can
Ms.
spread it out
Johnson.
across social media, and you can talk down on them, and you can make money off of it because you go and you spread it, and then you get up all
Hey,
these views.
put
and
the
then
camera
people
on yourself
think-
if you want to
think-
tell me off, Ms. Johnson.
I can put the camera where I want to. That's my legal
All
right,
right.
ma'am.
You are to appear, I will send the orders for you to appear personally because you're going to serve some time for this disrespect.
Mhm.
Ms.
It's
Johnson,
disrespect with what you having him do
Missy,
on camera under the
disconnect her.
circumstance.
This court hearing is adjourned.
Yeah, disconnect yourself because you're unlawful.
All right.
Across both of these hearings, the pattern isn't misunderstanding the law, it's resisting how authority actually functions inside a courtroom. Terms like jurisdiction, verified complaint, corpus delicti, and even rejecting citizen status are often used as shields. But in practice, they don't stop proceedings, they signal to the court that the defendant is prioritizing ideology over procedure. And that has consequences. In the first case, the defendant tries to control the process by challenging paperwork before entering a plea. But the court moves forward anyway. The system doesn't pause for philosophical objections, it follows procedural rules. That means the case continues, with or without his agreement. In the second case, the risk escalates. Now it's not just about legal arguments, it's about courtroom control. Interruptions, speaking without standing, and inserting a non-attorney into proceedings triggers something more serious: contempt. Contempt isn't about disagreement, it's about disruption. And once that line is crossed, the focus shifts. It's no longer just about the original charges, it becomes about obedience to the court itself. Even medical concerns, which could have been a strong legal basis for delay, lose impact when paired with resistance and disorder. The court starts questioning credibility, not just condition. This is the hidden consequence most viewers miss. Small decisions, like refusing counsel, interrupting proceedings, or using sovereign citizen language, don't just weaken arguments. They redefine how the court treats you. And once that shift happens, every future interaction carries more risk than the last.